Hi guys, and welcome back to my YouTube channel. My name is Salma Ahmed and this is Law Talks with Umati. So today I want to talk to you about hearsay evidence. If you watch a lot of movies or shows, you must have heard one of the characters say, "It's hearsay, it's not admissible in court." But I'm going to walk you through what hearsay evidence is and how it can be admissible in Nigerian courts. But before we dive into the exceptions to the hearsay rule, I'd like to tell you what hearsay evidence is. Hearsay evidence is a testimony by a witness who states what other people saw, heard, or experienced personally. Simply speaking, he was not an eyewitness to an event, but someone who was an eyewitness to that event told him. For example, Mr. A committed an offense, Mr. B saw Mr. A commit that offense, Mr. B then told Mr. C that he saw Mr. A commit that offense. Now, what Mr. C repeats is hearsay because he did not see it personally, he did not see Mr. A commit that offense. He was told by B, who saw Mr. A commit that offense. Now, onto the exceptions. Now, generally, hearsay evidence is inadmissible because of 4 reasons called the 4 dangers of hearsay. And the first one is risks of faulty perception. That is, we have different mental capacities and one person's perception of a thing might be different from another person's perception of an event. The second one is human memory. The human memory is infallible and we tend to forget things. The third reason is ambiguity, and this has to do with the use and communication of language. And this means that you may say something, but that is not what you really mean. And the language used might not convey the exact details of an event. The last one is insincerity. Human beings tend to lie, and they might be moved to do so if an event could be in their interest. But for every general rule, there is an exception. So I'm going to walk you through these exceptions to the hearsay rule. Now, the first exception to the hearsay rule is dying declaration. A dying declaration is a statement made by a deceased person. A dying declaration is based on the Latin maxim, nemo mariturus praeso mentire, and this means that a man will not meet his maker with a lie in his mouth. The rationale behind this is that at that moment, when the person fears for his life, every atom of falsehood is driven away from his mind and he is compelled to tell the truth, because obviously the only thing that is on his mind is that he's going to die. So he'll be moved to tell the truth and not falsehood. For example, in the early hours of 13th October 1988, a man who happened to be the bellman of his church went to ring the bell for morning prayers. On getting there, after he rang the bell, his wife heard a gunshot and then she heard her husband scream, "Anthony, Okoro has shot me." She rushed there and she met her husband bleeding. He was rushed to the hospital, but he died as a result of the gunshot wound. Anthony Okoro was convicted for murder based on that statement he made, "Anthony Okoro has shot me," which his wife heard. Now, normally, it shouldn't be admissible because she wasn't there. She did not see Anthony Okoro shoot her husband. But the declaration that her husband made at that point was deemed a dying declaration and it was admitted. Her testimony was admitted as evidence and Anthony Okoro was convicted based off of that. Now, not every dying declaration is admissible. There are conditions governing the admissibility of a dying declaration, and the first condition is the person making the declaration must have died before evidence of the declaration is required. The second condition is the declaration must relate to the cause of death of the person making the declaration. The third condition is the declaration is relevant only in trials for murder or manslaughter of the person making the declaration. Say if a person died as a result of injuries he sustained from another person, but the case as trial is relating to debt he owed someone, the dying declaration would not be relevant. The fourth condition is the declarant must have believed himself to be in danger of approaching death. Now, this one is a bit tricky. Let me give you an example. A man was hospitalized as a result of injuries he sustained from a beating he got from another person, and while he was at the hospital, a police officer asked him if he could make a statement, and he said that he could. So the police officer asked him if he thought he was going to die, and he said, "I don't know whether I'm going to die." And then he went on to give the statement on how he got his injuries. 3 days later, he died. The statement he gave was held to be inadmissible because at the time he made it, he wasn't sure that he was going to die. What you must understand is any declaration made by the deceased after he has abandoned the belief of being in danger of approaching death will not be admissible. The second exception is declarations made in the course of business. These are statements made in the course of business, whether verbal or written, by a person who has since died in proof of facts, which was the person's duty to state on record. The statement may be an acknowledgement of receipt of property or money or goods. Now, this exception to the Hearsay rule also has its conditions, and the first one is it must be relevant, and the person making the declaration must have died before evidence of the declaration is required. And the third one is the declaration must have been made in the ordinary course of business. Say if you're having a meeting, whose duty is it to record the minutes? Probably the secretary. And if the secretary records those minutes of the meeting, it will be held to be admissible should the secretary die, and evidence of whether the meeting was held is required in court. The fourth condition is that it may relate to acts done by the deceased person or by a third party, provided it is within his knowledge. Say if you have someone under you and you instruct them to do a task and they do it, it is within your knowledge, so that will be held to be admissible. Now, the third exception to the Hearsay rule is declarations against interest. These are statements made by a deceased person against his interest, and this mostly has to do with money or the ownership of property. For example, in Higham versus Ridgeway, the question in dispute was to the date of birth of a person, and an entry was found in the book of a late midwife where he records payments made to him for the delivery of children. And one of the entries was for the payment made to him for the delivery of that person. It was admitted as evidence for the date of birth of that person because it was against his interest. Had he recorded that he hadn't been paid, then that would be in his interest because then he would have to be paid. But he recorded that his payment has been met, therefore it was against his interest. And there are conditions governing the admissibility of declarations made against interest. It must be relevant. The person who made the declaration or statement must have died before evidence is required. And the third one is the person must have had special knowledge of the occurrence. See, that male midwife that died had special knowledge because he was the one that delivered that person. Also, it must definitely be about money or ownership of property. The fourth exception to the Hearsay rule is declarations as to public right and general interest. These are statements made by a deceased person giving an opinion as to public rights and matters of general interest, such as customs. For example, if you have a 100-year-old person whose memory is sharp, they're more likely to tell you and to give you an accurate account of what happened during their time, their customs, their rules and everything, more than a book could. So those kind of statements that they make about customs or traditions will be held to be admissible in a court. Obviously, this exception also has its conditions. It must be relevant. The person making the declaration must have died before evidence of the declaration or statement is required. It must relate to a public right, such as the use of a highway or a river. Say these people used this river when they were here, when they camped here, or these people did not use this, and old tales and stuff. And the deceased must be a person who was likely to have been aware of the existence of such a public right. Say if something happened ages ago, you should find a very old person and ask them. Chances are they know, especially if they were alive then. And the declaration must have been made before the controversy arose. Now, the fifth exception to the Hearsay rule is pedigree declarations. They are statements made relating to the existence of a relationship by blood, marriage, birth, or death of a person. And for example, if Mr. A makes a statement before he died that he attended the wedding of Mr. B and Miss C, that would be held as admissible of evidence of the marriage of Mr. B and Miss C. And just like the others, this also has its conditions governing its admissibility. And the first one is it must be relevant. The declaration must have been made. The declarant must have died before evidence of the declaration is required. And the third one is it must relate to the existence of a relationship, a marriage, or adoption of some person. And the statement must have been made by a declarant shown to be related by blood to the person whom it relates, or by a wife or a husband. Let me give you an example. The testimony of a woman who had served a family for 20 years was held to be inadmissible because she was not related by blood. Even though she worked for them for 20 years, she knew them in and out, her testimony was not admitted. Another example is a person died and it was found in one of his journals that he was adopted. It was held to be admissible because he had means of knowing it. Obviously, he's the person he should know, especially if he's been told. And the last one is the statement must have been made before the controversy arose. You can't come and say that, oh, I know this person married so and so when the case is ongoing. The statement must have been made way before the controversy arose, and then the person has already died. The sixth exception to the Hearsay rule is declarations made by testators. These are statements of a deceased person as to his testamentary intentions or as to the contents of his will. For example, in Sugden versus Lord St. Leonards, a famous lawyer and judge died, and his will was nowhere to be found. But his daughter knew most of the contents of the will by heart because her father had told her. She and a couple of other people testified that her father said this after he had completed the will, and that was admitted as evidence to the contents of his will. The conditions governing the admissibility of declarations made by testators. The first one is the will must have been lost, or that there are two wills and they're in contention as to which one is the original one. And the last one is when a question arises whether the will is genuine or not. Now, when hearsay falls under any of these 6 exceptions that I just told you about, it will be admitted by a court, especially if you have a good lawyer. So make sure you invest in a good lawyer. Thank you. That's that on hearsay evidence today. See you next time, and thanks for watching this video. Don't forget to hit the subscribe button, like, and share with your friends. Thank you.